So I want to get into this new motion that was filed by R. Kelly's lawyer in New York, Thomas A. Farinella. All right, now he's filed another motion. Essentially, it is for the COVID-19 release. In this new motion, he basically gets into a lot of factors. I'm going to read a lot of this to you. This video is not going to be short. It's going to be a little bit lengthy, just so I can get some of the key factors into this. It's not going to be too lengthy, okay? Not no more than 20 minutes. So we're going to get into some of these rebuttal parts that he has against the initial rebuttal that they had did. He had put in a motion previously about the COVID-19 and all like that. It was rebutted by Judge Ann Donnelly. So he has now put in another motion. In this motion, it's much more thicker. It's 224 pages total. But I got into the part where I needed to get into, and we're going to just focus on that portion. So again, it was filed on June 29th, 2020, just recently. And it is, again, let's see. It is a docket. It says Thomas A. Farinella declares under the penalties of perjury pursuant to, and he puts a case law in there. He says, I am the attorney with the law office of Thomas A. Farinella, PC. I represent defendant appellant Robert S. Kelly, and I offer this declaration in support of motion for an order reversing an order of pretrial detention entered by the district court, Honor Ann M. Donnelly, on May 15, 2020. I respectfully submit with this declaration the memorandum of law in support of our Robert S. Kelly's motion for release of pretrial detention dated June 29, 2020. So in this motion, now I went on a couple platforms and I noticed where they were saying that it is a motion for him to be released due to COVID-19. That's a little bit in there, but that is not all that is in there. Essentially, what this lawyer is doing is he's saying it is not right for R. Kelly to be locked up. There's laws and provisions that show that he should be out of jail. So, given today's injustices and everything that's been going on lately, a lot of these legal people, for lack of better terms, a lot of these people, they need to take and pay better attention to what they say and how they act in the courts and everything, because everything in detail is now going to start getting looked at, especially when you got cases with black men, R. Kelly. So he's being done unjustly, regardless of what anybody says. That's a fact. That's a fact. And in this motion, Thomas points that out, and it's a wonderful thing. So real quick, so let me get in this. He says Mr. Kelly has been charged in this district with violating, and he puts in all the codes, their case law kind of codes for his case or whatever, and for violating such and such and such and such and such and such, and then all of which are qualifying crimes involving a minor. Therefore, there is a rebuttable presumption of pretrial detention. On July 16, 2019, Judge Harry Leinenweber entered a permanent order of detention in the Northern District of Illinois. On August 2nd, there was a bail hearing held in district court before Magistrate Tiscone. The transcript of the bail hearing is annexed here too as Exhibit B. Now, in this, he pretty much goes through this all the way through. And he has all the exhibits listed and everything. This is in detail. You cannot read 224 pages in like 24 hours. It's just not going to happen. So whoever comes back, if the judge comes back again and denies this motion in less than 24 hours, it's going to be crazy, because this takes a lot of research. I mean, what he has done is thoroughly researched the case, looked up additional case laws outside of R. Kelly's case, brought him back and said, this is why he should be released. And it's beyond just the COVID-19. It's based on the fact that R. Kelly is being held and he should not. He should be presumed innocent until found guilty in the court of law. And he states that in this motion. And that is what is going on here. And as far as COVID-19, he clearly states in here, let me get to the right page so I can actually read for you guys word for word what they're talking about. He kind of gets in it and he says that R. Kelly has pre-diabetes And due to the COVID-19, here you have everyone in the jail system is quarantined. Not even quarantined, they're just on shutdown. So they're not able to be active and get out and get the exercise a diabetic needs, a pre-diabetic needs, to stop them from becoming a full out all diabetic. So in this motion, let me get to it. Give me just a moment here. There's a lot of stuff in here. Shout out to the lawyer. He knows what he's doing. There's a lot of people out here who don't have a belief in the lawyers in this case. And, you know, sometimes you get it. When things aren't done in the way it should be, you kind of get antsy. What's going on? Why aren't things being done this way or that way? And that's what's going on with a lot of people who support R. Kelly. They just want instant results. And unfortunately, it just can't happen that way. It just won't happen that way. So I'm going to go down into the document and get to the part where we need to get to. All right, so for those of you guys who have the documents, I don't know, for those of you who don't, whatever, I'm just going to state it's item number 27 on page number 8. And he goes in and he says, Mr. Kelly is pre-diabetic. His diagnosis, as the court noted above, requires diet, exercise, and weight loss to be managed. The defendant is on total lockdown and cannot exercise or lose weight. This is exacerbating his pre-diabetes and puts him at a risk for developing it. As far as the court's review of the defendant's medical records and conclusion that he is not uniquely at risk or contradicted by the CDC, per the CDC, because COVID-19 is a new disease, more work is needed to better understand the risk factors for severe illness or complications. Potential risk factors that have been identified to date include age, as discussed, and he is 53 years old and certainly not in a low risk category. B, race, ethnicity. As reports show, African Americans are susceptible. C, gender. D, some medical conditions. As discussed, he has prediabetes that is not properly being managed, as well as he had surgery recently that also may affect him. And C, poverty and crowding, both of which exist in prison conditions. So that's the rebuttal he's giving, and it's in factual. He's lining it out for them. Like, how you can't spell it out any more clear than that. So then item number 29, he goes in and he says, although the CDC guidelines are important to follow, this is completely unknown virus. Many people have developed severe complications, such as fibrosis of the lungs, long-term permanent pulmonary problems, and there are those that have died from the virus, even though they were categorized as most at risk for contracting. So he goes in and he explains that. I love how he itemizes it, and he's getting into the details, as he should. You know, so then they go in and they say, the court did not address the issues raised by the defense counsel regarding Mr. Kelly's right to prepare for trial, and the fact that he has literacy issues, making it impossible to prepare for trial without being able to meet with him in person. At present, counsel cannot meet with Mr. Kelly to prepare him for the September 2020 trial date in the Eastern District of New York. Boom. Just that. So then he goes in. Now he's ending this right here. Again, this is 224 pages. I wanted to hit the certain spots. There's another spot I want to hit with you guys in regards to Azriel and where she takes place in this. But so he ends it and he says, wherefore, the reason stated in the attached memorandum of law, this court should enter in order reversing the district court's order of detention and directing that Mr. Kelly be released from custody, subject to appropriate conditions of release and any other conditions supported by the evidence and needed to reasonably assure community safety and risk of flight so Mr. Kelly can prepare for trial. So he says, I declare under penalty of perjury that the foregoing is true and correct to the best of my knowledge. And then he signs his name, Thomas A. Fernella. All right, so in this portion, what we have is the United States. They filed again, United States Court of Appeals for the Second Circuit. And this is going to be the United States Plaintiff Appellee against Robert S. Kelly, Defendant Appellant. So this is appeal from a detention order of the United States District Court for the Eastern District of New York. Now, he's now inserting the law. So it says memorandum of law in support of Robert S. Kelly's motion for release from pretrial detention. So let's read in here exactly what he has to say. This is awesome. Brace yourselves. So he says courts should always bear in mind that it is only a limited group of offenders who should be denied bail pending trial. So then he inserts a case law here, and it's dated for 1987. He inserts another quoted case law, which is dated for 1984. And it says, after all, denial of bail under the Bail Reform Act was not intended to apply to all defendants charged with serious crimes, but only a small but identifiable group of particularly dangerous defendants as to whom neither the imposition or stringent release conditions nor the prospect of revocation of release can reasonably assure the safety of the community or the other persons. Then they insert another cases law kind of thing there. But then they go in and they say, thus as the Supreme Court has cautioned, in our society, liberty is the norm, and detention prior to trial or without trial is carefully limited exception. Then they insert another case law. It doesn't have a date, but it says United States versus Salerno. And then they give the case information there. And it says here, defendant Robert S. Kelly, Mr. Kelly, moved for pretrial release in light of the coronavirus pandemic and in order to be able to prepare for trial. The circumstances that exist as a result of the COVID-19 pandemic will continue to exist into the foreseeable future and have made it impossible for Mr. Kelly to prepare for his September 2020 trial if bail is not granted. It is undisputed that Mr. Kelly cannot read or write. Therefore, unlike most defendants, he cannot spend hours reading and reviewing the documents that are relevant to his case. He cannot make notes about those documents. He cannot meaningfully communicate in writing with his lawyers, and he cannot meet face-to-face with his lawyers. He has essentially been cut out of the discovery and trial preparation process. Moreover, because of the pandemic and the conditions imposed by the MCC Chicago, because of it, his overall communications with counsel are subject to crucial limitations. This is particularly troublesome as the means of those limited communications do not even possess the safeguards of confidentiality that are necessary to engage in meaningful attorney-client conversation. Moreover, there is no denying that this extraordinary time and that the issues of the ordinarily affect bail determinations have to be viewed differently and more liberally. Furthermore, the allegations in the indictment in this case span 3 decades. The indictment alleges in some that Mr. Kelly's care as nationally recognized. The indictment alleges in some that Mr. Kelly's care as nationally recognized singer and performer constitutes a RICO, racketeering enterprise. Mr. Kelly has lived that career and is in the best position to assist counsel in the review of the discovery. While the defendant is often the best historian in any case, Mr. Kelly's contribution is even more crucial here because the trial court has allowed the government to conceal the identities of some of the alleged victims who will be key trial witnesses. The district court concluded that Mr. Kelly poses a significant danger to the community, that no combination of bail conditions can adequately address, that he is likely to flee, and that the judicial system's oversight capabilities have been curtailed because of the pandemic. However, as the records supports, even applying the most stringent standard of review, release should be granted. Then they put in a case law dated for 2019. United States versus Bastani. Okay? So, they said, in brackets they put in, we review a district court's order of detention for a clear error and will reverse only where, on the entire evidence, we are left with the definite and firm conviction that a mistake has been committed. Based upon the record before the district court, there is no doubt that a mistake has been made, and it is definite and clear that Mr. Kelly is neither a flight risk nor does he present a danger to the community. As to the nature and seriousness of the danger purportedly posed by his release, the concern expressed by district court and the government is that Mr. Kelly may attempt to obstruct justice because he has been charged with obstructing justice in another case. It is certainly not that he is danger to commit any type of sexual misconduct. Putting aside for a moment the fact that he is presumed innocent, the law does not concern itself with allegations of former conduct, but rather speaks to a real and present danger. Here, the danger is merely speculative and without record support. The expressed concern also ignores reality, or as they say, the proof is in the pudding. One of the government's alleged victim, Jane Doe's, apparently at the same time she was cooperating with the government, was still living with Mr. Kelly. After Mr. Kelly's arrest and incarceration, the government did not, as would be customary, even seek to bar him from contacting any possible witnesses. They were afforded, pre-pandemic, personal one-on-one visits at the MCC Chicago. Yet through months of contact, there was not a single allegation of any kind of nefarious behavior on Mr. Kelly's part with respect to this Jane Doe, including any allegations that Mr. Kelly ever tried to influence her, pressure her, or direct her to do so with respect to any other potential witness. So given that the district court clearly erred in finding that Mr. Kelly is irremediably dangerous and that no bail conditions can reasonably assure community safety and that federal pretrial services are incapable of monitoring him, the question becomes that conditions are in fact appropriate. Certainly conditions can be constructed that would alleviate any legitimate concerns. Location monitoring can be employed. The use of electronics by Mr. Kelly can be restricted or completely eliminated, and Mr. Kelly can be denied internet access. The real issue here is whether, by denying him bail, is it appropriate to put him in a position where he cannot assist his counsel to prepare for future upcoming trial in September 2020. They go into this, they list the facts. It's a lot of stuff. It says Mr. Kelly should have been released from the start. Here you go. Mr. Kelly should have been released from the start in these matters, and the initial decisions to detain him were themselves erroneous. But now with the COVID-19 pandemic, there has been a catalytic change in circumstances that cause for his release. The simple fact is that a jail setting is not somewhere that is safe for someone, it's not safe from COVID-19. The conditions at the MCC Chicago have deteriorated to the point they are arguably inhumane, even for the healthiest of persons. Contrary to the district court's finding that Mr. Kelly's medical condition is insignificant and treatable, Mr. Kelly has been required for months now to be in a permanent lockdown setting in a cell because of the COVID-19 crisis. He has had minimal opportunity for movement, no opportunity for recreation, and no opportunity for social interaction with anyone other than a cellmate. So they go in this, and it's pretty lengthy. Again, it's 224 pages. I don't want to keep you guys here tied up. I'm looking at the time right now, but I wanted to feed you guys that information. So this lawyer is actually going after a lot of things that need to be going after. Jane Doe, she lived with him. She didn't see anything. She didn't mention, there was no cops called on him, nothing going on violently at all while she was with him, while cooperating with the government. So now all of a sudden, here we are. Have good thoughts and hopes for Mr. Kelly. And hopefully he receives the justice that he needs, because there's a lot of stuff happening with him in this case. It's obvious. A lot of people are lying in this. A lot of people are dropping out of this case against him because they didn't realize it was going to go this far. But, you know. Anyways, guys, till next video.